Hello and welcome to episode 56 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
I'm Joanna Baron, Executive Director of the CCF.
And I'm Christine Van Geyn, the CCF's Litigation Director.
In today's episode, I'm going to talk about the BC Conservatives' proposal to fix healthcare and why I think the Canada Health Act needs to change if we want to see any real improvement.
And I just got back from Ottawa, where I was at the Digital Justice Summit discussing Bill C-63, the Online Harms Act. So I'm going to tell you all about how that went and what the aftermath was.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to update you on some potential litigation to right the ship of Canadian federalism, a topic that I spoke about this weekend at the Canada Strong and Free Network conference in Alberta, which our friend Rachel Gilmore tried to cancel unsuccessfully, I can report. So I was talking on a panel with Barry Cooper and Ted Morton, and they're two members of what's called the Calgary School. That's the political science department that has led the way in conservative thought since the 1990s. And needless to say, it was very intimidating being on a panel with these two guys because they really know their stuff, and they were actually around for a lot of the constitutional debates that I just sort of have been reading about in books. And Cooper gave a talk where he said that Laurentian Canada has viewed Alberta as a colony to exploit since the very beginning, and the imbalance of the Senate, the unfair equalization payments, and even industrial policy that favors Ontario's auto sector over oil sands are examples of how he thinks this remains true today. And Cooper was involved in crafting the Sovereignty Act, which we've talked about on here before. And he maintains that it's purposefully unconstitutional. And that's a pretty provocative thing to say. And I don't think quite right, since the main thing that it does is direct Alberta's public service not to implement federal laws, which it has a constitutional right to do already. Cooper concluded by pointing out that since the Supreme Court has given Quebec the green light to negotiate separation, the same is true for Alberta, and if Laurentians don't start being more fair to Alberta, separation will be on the table, he thinks. Now, Ted Morton was also pretty provocative, stating that the courts are heavily biased toward centralist, pro-Ottawa, pro-woke, pro-liberal party values and interests, and he says this is mainly because the Supreme Court tends to have 6 members appointed from Eastern Canada and only 3 from the West. 3 or fewer, I guess, it depends. Morton pointed out that the region that judges come from seems to clearly influence how they rule, with the carbon tax reference being, in his view, a prime example. In that case, 4 Alberta appeals court judges found the carbon tax imposed by Ottawa was unconstitutional, as did 2 Supreme Court judges who are both from oil-producing provinces, Justice Brown from Alberta and Justice Rowe from Newfoundland and Labrador. Well, nearly all the other SCC judges and the Ontario Court of Appeal judges sided with Ottawa on that case. And to fix the imbalance, Morton is proposing, again, some pretty provocative things like provincial appointment of Superior Court judges and Supreme Court judges, a constitutional ballot challenge to Bill 13, which is a bill passed in 2022 that requires mandatory bilingualism for all SCC judges, and expanding the size of the Supreme Court from 9 to 10 with a mandatory 3 from Western provinces, 1 for Atlantic Canada. So the provincial appointments thing and expanding the size of the court seem fairly unlikely to me, but I do think he's right that a Bill 13 challenge could be a potential winner. And what Bill 13 did was update the Supreme Court Act to state that every judge of the Supreme Court or the federal courts needs to understand French and English without the assistance of an interpreter. In other words, to be on the SCC now, you have to be fully bilingual, and the vast majority of Canadians are not. The Act also says that people applying to be judges on the Superior Court also have to indicate their skill level. And again, this biases things towards mostly bilingual judges in provinces, even like Alberta, where no one is bilingual. Obviously, Bill 13 was done to please Quebec, and I think it's pretty indefensible considering that there is already constant translation in the courts, and considering that it weeds out more than 95% of Canadians outside of Quebec and New Brunswick who didn't grow up speaking French. Maybe they didn't have the resources to, or they just didn't have that background. And Quebec has been guaranteed 3 seats on the Supreme Court through the Supreme Court Act, which you might think is a mere statute, but the Supreme Court has already decided in the case where they nixed Stephen Harper's appointment of Justice Nadon, that the composition of the court as it existed in 1982, including eligibility requirements, is constitutionally entrenched. And Section 41 of the Constitution Act 1982 lists the composition of the Supreme Court as one of the things that require unanimous consent of all provinces and Parliament to change. So there's actually a pretty good argument here based on case law and the text that C-13 shouldn't have been passed without an amendment to the Constitution. I also think there's a possibility that maybe a judge who applies, who's not bilingual, maybe they're from an ethnic background where French was not a priority, could potentially challenge this on the basis of the equality provisions of the Charter. So that's one potential area of litigation that we're looking into a little more. A second potential challenge that we talked about is a challenge based on Section 36(2) of the Constitution Act, which is the equalization section. And this is something I'm a lot more skeptical about. I think it would be not very fruitful, especially for provinces like Alberta. Section 36(2) says that Parliament is committed to the principle of making equalization payments to ensure that provincial governments have sufficient revenues to provide reasonably comparable levels of public services at reasonably comparable levels of taxation. And there are essentially 2 views on what that means. One is that committed means obliged or required to take a certain action. So this is a justiciable section. And the other is that committed just means, you aspire to take a certain action, you're going to make best efforts. And in that sense, this Section 36 of the Constitution isn't even justiciable. Now, I won't get into why I think it probably is justiciable, but assuming that it is, it's still not going to be very helpful to a province like Alberta. You'd still need to show that you can't, as a province, provide reasonably comparable levels of services at reasonably comparable levels of taxation without a change to the equalization formula. And for the most part, the levels of taxation are pretty comparable. The outliers are provinces like Nova Scotia, which has a tax rate of 21% for those making over 150,000, versus Alberta and Ontario, where it's almost half that at 12%. So Nova Scotia might be able to say, look, we're taxing at twice the rate of other provinces, and our healthcare and education are noticeably worse. So we need even more equalization. But a province like Alberta trying to say, look, we're paying too much to actually provide good services, that's going to be a much bigger uphill climb. So finally, we talked about a third potential source of litigation, and that would involve Section 92A of the Constitution Act, and using that to challenge the clean electricity regulations, which I think is a much more fruitful line of action than Section 36. So the clean electricity regulations proposed last year by the Trudeau government and expected to be enacted later this year aim to phase out gas-fired electricity generation by 2035 and to prevent gas-fueled power stations from opening unless they have sufficient carbon capture technology in place. And this would basically be impossible for Alberta and Saskatchewan to achieve without massively driving up electricity costs, which would harden the economy and harm regular people. So Section 92, again, that's the section that gives provinces the exclusive right to legislate over exploration, development, and conservation of non-renewables, and also of facilities for electricity production and generation. And the reason I think this challenge could succeed is because of the Impact Assessment Act decision, which we successfully intervened in and got late last year. So in that case, the government found that the Impact Assessment Act decisions were not being driven by matters within federal jurisdiction like the Peace, Order, and Good Government clause, but were in fact driven by things like Section 92A. And so if they couldn't, get away with that, I don't think Ottawa's going to be able to get away with these clean electricity regulations, which are also driven by, this vague allusion to climate change, according to the government, but are really driven by a desire to control electricity production and regulation. So thank you to all the federalism nerds who came out to my little TED Talk. Joanna, you were at a conference also talking about federalism on Saturday while I was in Alberta. Do you want to tell us anything about that?
Yeah, so I was at, I believe it was the first time it was hosted. It was organized by the Young Leaders Coalition, a young, very impressive young man, very ambitious, named Elijah Nikiforuk, basically put the whole thing together. I think he's a university student, and there were about 50 other university undergraduate students there. And when I arrived, it was hosted at Muskoka Woods, which is a summer camp in Muskoka. And when I arrived, there was a retired military general who was giving a talk about national defense, and that was a little intimidating. But my session was about federalism and national unity. And I think the students were surprised to hear that my take is that basically honoring federalism, the intent of the founders of Confederation to properly separate out spheres of authority and push back against what has been a pattern of federal overreach, basically since the Supreme Court replaced the Judicial Council, the JCPC, Judicial Privy Council, where it was like British lords who didn't really have skin in the game, and was replaced by these centrists who started reading into these areas of new legislation, increasing central government overreach. So basically, and I think, Josh, you made this point in your column about the Impact Assessment Act back when the decision came out about a year ago. You said the decision actually prevented an existential threat to Canadian national unity, because if the Supreme Court had signed off on the No More Pipelines bill, which so clearly gave the federal government a veto and so clearly intruded on provincial jurisdiction, the knife cuts both ways. So on the one hand, a future, let's say, conservative government dominated by Western MPs could ride roughshod over projects in Ontario and Quebec. And obviously Ontario and Quebec can, and I'm sure Barry Cooper would say do, interfere with Western infrastructure projects, highways, mines, stuff like that. So I really made the pitch to the students that in a country like Canada that has so much economic diversity, so much natural diversity, like the economy of somewhere like Newfoundland is so radically different from Alberta, where natural development, oil and gas is still a huge part of industry. There's a real wisdom in calibrating and also allowing the separation of spheres of authority to be a check of excessive power. And if you want to read more about that, you can read our Freedom Through Federalism ebook. So the students got it. I got a lot of questions about the Sovereignty Act, which it's really interesting, by the way, to hear that Barry Cooper, I've heard him say this, but that it's designed to be unconstitutional, because I think that's basically our conclusion about it, that either the Sovereignty Act is constitutional, but it doesn't do much other than reaffirm what Alberta already has the right to do. Or if it's more than that, it's just unconstitutional, and it's just a ratcheting up of some type of brink of Wexit. So that's interesting, but I won't really say much more about that. So yeah, Christine was also on a field trip this weekend, or starting on Sunday. Anything to add about Josh's very juicy and interesting panel?
Yeah, that sounds so interesting. I would have loved to be there, but we were all at kind of competing events this week in various parts of the country. So the one thing that Josh, did anyone talk about the plastics case on your panel? Because that's a really big federalism case that's gone to the Federal Court of Appeal. No?
No, nobody talked about it. It's a good point.
Yeah, so that also has really serious implications for the clean energy regulations. For those of you who listen to the podcast regularly, you'll know that we intervened in this case that came out of Alberta about it came out of Alberta, but it's a federal case brought by a consortium of plastics companies, and that these plastics regulations that the feds had come up with, where they basically designated every single plastic manufactured item, like from straws to medical devices to helmets, as a toxic substance under the Canadian Environmental Protection Act regulations. They said all of this is toxic. And a federal court sided with the Plastics Consortium. They struck down the order. It went to the Federal Court of Appeal. And what was interesting is the feds were using the criminal law power to justify these regulations. And there has been, ever since the Supreme Court held 25 years ago that the feds can use the criminal law power to regulate the environment in a case called R and Hydro-Quebec, there's been kind of like a big back and forth about the scope of that power. And this case, the federal plastics case, was a case where we intervened to sort of clarify the scope of that power. And the lower court found that the threshold was not met, that this was over the top to call every single plastic item a toxic substance. And the implications, the case has not been decided at the Federal Court of Appeal yet, but the implications could be felt pretty quickly because it's the criminal law power that we expect the feds to rely on to justify the proposed clean energy regulations. And those are the regulations that have not been well received in provinces like Alberta and Saskatchewan that rely on fossil fuels for electricity. The criminal law power might also be relied on by the feds and the Minister of Energy for proposed greenhouse gas emissions cap regulations. And it will be really interesting to see how that decision plays out. It will have big implications. It's interesting no one talked about it. But I do think Alberta has been on like maybe a mini winning streak with a few of these types of cases. Anyway, let's move on. Joanna, do you want to talk about your news headline this week?
Yeah, let's take a quick break and then we come back. We'll talk about the BC election. Okay, so BC has been having a very interesting political season. I'm very intrigued by the recent machinations, but as healthcare policy and healthcare law geeks, we have been particularly interested in looking at some of the healthcare policies, which, in any jurisdiction in Canada, given how much of a proportion of the sort of public obligations of the state healthcare is in Canada, healthcare policy, and given the crisis in pretty much every jurisdiction around healthcare, that is bound to be one of the meatiest items on the plate. And so we were interested to see some of the specific proposals brought forward by John Rustad, who is, of course, the leader of the BC Conservative Party, which is running pretty much neck and neck with the NDP. And he has a series of fairly bold healthcare reforms. So his proposals include tying public funding to patients rather than block transfers. So currently, healthcare authorities, which is kind of how it's organized in BC, healthcare authorities will just get a block sum based on the political budget. So they're proposing instead to tie the funding to patients. He's also proposing to redirect funding from administration, so basically bureaucrats, to frontline care. He would implement a wait time guarantee, which would allow patients to be treated out of province if their wait times exceed medically recommended limits, which we know a very sizable portion of people are on wait lists that exceed medically required limits. And so this plan has attracted a lot of criticism from the usual suspects like the BC Healthcare Workers Union, which has a sort of hit piece that we can link to where they say basically, first of all, they go after the fact that there is reporting that Rustad consulted with Deloitte, and they say Deloitte is a company that has deep ties to big pharma. So I'm not sure how substantive of a criticism that is, but they're angry about this. But basically, I think a lot of the proposals in Rustad's plan is a step in the right direction. We know some colleagues of ours have been consulting with him on some of these ideas, particularly our colleagues at the Montreal Economic Institute. And my friend Danielle Dufal has been really pushing this idea of funding patients, not healthcare per se, and tying funding amounts to outcomes and to patients, which seems to me to be a very humane idea. And we also know, and Rustad talks about this, that Canada has, for example, 10 times the number of healthcare administrators. So basically, paper pushers, not to denigrate them, but bureaucrats compared to Germany. Our healthcare spending is amongst the highest in the world. Our outcomes are second to last amongst all OECD countries. And yet, Rustad's plan also is still painting sort of within the lines, and it's not really going boldly enough that as boldly as we think our current healthcare crisis requires. Namely, it still relies on an entirely single-payer government model. Canada, just to remind everyone, we've said this millions of times, but Canada is still the only country in the Western world that aims to eliminate all forms of privately funded, medically necessary healthcare, to entirely suppress the emergence of any type of private insurance system. We know that secondstreet.org did a study that showed that Canadians make over 217,000 trips per year for healthcare, and they could be getting that healthcare here. So there is a market demand, and governments have been artificially quashing any response to that market demand from emerging. So why is Rustad not going further? Well, he certainly seems to be inclined to do so. And this week, there was reporting in the Globe and Mail that he directly addressed the federal legislation that he says is keeping him from going further. Very rare for provincial politicians to call out the Canada Health Act, which is the federal legislation which governs, which necessitates the requirement that provinces establish universal healthcare systems, and also establishes the conditions for the federal government to give their cash transfers to the provinces. And this week on the campaign trail, Rustad said that it's weird, but that is what the silly Canadian Health Act is all about. And hopefully we'll get some changes there as well. Basically saying that the Canada Health Act limits him in going further and allowing, in some cases, perhaps with other types of regulation, requiring maybe, there's been talk about minimum amount of hours that doctors have to remain in the public system and can do private care alongside that. But he's just, in his view, prevented from going further because of the Canada Health Act. So just briefly, I think it's good that Rustad is bringing this to public awareness. And it's a little bit complicated. So the general aim of the Canada Health Act is not to restrict private healthcare. It's just to ensure that all Canadians can enjoy reasonable access to healthcare, which is free at the point of delivery through the public plan, paid for out of the public purse. And in Chauli, the sort of seminal 2003, is it 2003? I think so. 2003 Supreme Court of Canada decision, which found that Quebec's ban on private insurance were unconstitutional in the circumstances. Justice Deschamps wrote that the Canada Health Act does not prohibit private care, but rather only provides a general framework that leaves considerable latitude to the provinces. And I think this is true, but there are many provisions in the Canada Health Act which are clearly designed to punish provinces and, of course, by extension, patients for what it calls extra billing and user charges. So extra billing is defined in the Act as billing for an insured health service rendered to a person by a doctor in an amount in addition to any amount paid for that service. So basically, it's a form of cost sharing. And the Canada Health Act makes clear that provinces that allow extra billing or user charges will be subject to clawbacks and fines from the federal government, which the Trudeau government has been very aggressive in enforcing. They charged Quebec $41.9 million, British Columbia $17 million, and Alberta almost $14 million just for the sin of allowing its citizens to pay directly for things like MRIs rather than remaining on wait lists. So There's actually a pretty elegant fix to all of this, and it's also a fix that consistent polling tells us Canadians want. Canadians are very open to healthcare choice, to allowing there to be a parallel healthcare system as there is in the Scandinavian countries, in Australia and New Zealand. So it's not public opinion that is holding this back. It's this weird Gordian knot of healthcare that is just untouchable territory so far in Canada, but I do think it's changing. And someone like Rustad coming out and addressing it directly is a very positive sign. So the federal government should, I don't have any hope under the current government, but perhaps a future federal government should simply amend the Canada Health Act, remove the extra billing and user pay provisions that have held provinces back from pursuing policies that they think will work for them and their populations to improve healthcare delivery and outcomes. Sky would certainly not fall. The Canada Health Act would continue to require that provinces offer universal care free at the point of delivery. And, the status quo just can't continue. We know that a majority of judges, the BC Court of Appeal in 2022 found that BC's Medicare Protection Act provisions, which ban private insurance, have been so harmful as to violate not just the right to liberty, but also the right to life. And speaking of federalism, this would be a very, useful deployment of the federal principle to allow diversity in policy and government. If John Rustad wants to try out allowing forms of private pay insurance, then let him do that and let the rest of the country see how BC fares. And react accordingly. And if you don't want to live in BC under such a healthcare policy, you can move somewhere else where they're taking a different approach. Part of how federalism works is by facilitating this type of diversity in governance models within a single polity. That's my spiel for this week on BC's healthcare plan. Christine and Josh, have you guys been watching the BC election? Christine, you were out in Vancouver with me the week before last, where we had a full day discussion about healthcare policy, and there seems to be really interesting momentum in BC in this election around this topic. What do you think?
Yeah, I think that there's a lot of interesting things happening in BC, but I kind of actually want to talk about segue how this whole conversation is evolving in Alberta as well. And I know that Josh is going to talk about this a little bit in his bad legal takes for this week. But yesterday, Alberta Premier Danielle Smith proposed some amendments to Alberta's Bill of Rights, which is it's not a constitutional document. She called it, I forget what she called it, like she called it sort of constitutional, which
Maybe quasi-constitutional?
That's correct.
She didn't use that term.
Yeah.
But she said it's like a constitutional document. I mean, it's just a piece of legislation that can be modified, but other pieces of legislation in Alberta are supposed to be consistent with it. But I'm not going to talk about the changes. Josh will talk about the changes, but there is a section of Alberta's Bill of Rights currently that protects against government action that violates security of the person. And this is already protected in Canada's charter. It's also protected in Quebec's charter. And that was the basis on which the Shaoli decision at the Supreme Court, it was actually in 2005, Joanna, I just checked. The Shaoli decision was based on the Quebec charter, which is kind of like the equivalent to the Alberta Bill of Rights. So one of our friends who was involved in the conference we were at in BC messaged me following the Premier's proposal to make these amendments in Alberta, and he said, could there be a challenge against the ban on private options if it threatens security of person in Alberta? And that's a really interesting idea because it was the Quebec charter, so basically the equivalent, that Shaoli was decided on. So I think there is potential there for a similar argument. I mean, it will depend on the specific legislation being challenged. I mean, there is provincial law in Alberta that bans private payment for surgery. So sort of similar to what was challenged in Shiuli, although that was more the prohibition on private insurance. So I think that there is potential there for some type of case, depending on the legislation and depending on the facts of the individual patient who's bringing the challenge, because that's really important. That was important in the Shiuli decision. It was important in the Canby decision in BC. So there actually doesn't even need to be a change in the Bill of Rights in Alberta to bring something like that. But that really piqued my interest when that was announced yesterday, even though this section security of person type section 7 type protection already exists in Alberta. Josh, what do you think of all of this?
Yeah, I'm really excited about the idea of trying to find an Alberta bill or Alberta law to challenge using the Alberta Bill of Rights. It's a really interesting idea. The Canada Health Act would still stand in the way, so a quicker route would be for a future government to just say, look, we're going to continue to require that provinces provide universal care without charging people in order to get federal money, but we're going to take out these punitive provisions that actually fine provinces when they allow people to pay for extra care, whether through insurance or by paying for a private surgery when a surgeon's got time and space to do that. Really interesting thing I saw today is the Globe and Mail published a new survey about healthcare, and they found that there's been a huge increase in the number of people that are open to major reform. It's now 73%, which is up 14% in just 2 years. So that's pretty huge. And the other thing that's really interesting is that most Canadians, more than 2/3, say that they're open to allowing people to buy health insurance for medically necessary care, which is effectively banned in most provinces. Quebec, it's legal because of the Chaoulli decision. Ontario, it's fully banned. Other provinces are somewhere in between. But 68% of Canadians think you should be allowed to do that. Like, obviously, you should be allowed to buy insurance for your own health needs. Like, what could be more important than your own health, right? You could buy pet insurance, but you can't buy insurance for your own family's healthcare. So it's good to know that most Canadians are on board with that. And a very high number of people actually said they would buy it themselves, which is 37% said that they would buy it if it was allowed. They also found that a very large number of people say that you should be allowed to go and pay privately for things like MRIs and cancer screening. 36% said they would pay to avoid having to wait in the ER. 40% said they would be willing to pay privately for MRI scans. 44% said they'd be willing to pay for cancer screening. So, like, I think you're right, Joanna. Like, the conversation on this is just moving so quickly, and public opinion is moving so quickly that I think we could see, a BC government make some big changes, especially if a new Conservative government next year, assuming that the Conservatives were to win, takes out those parts of the Canada Health Act that are really blocking this from happening right now. Just another interesting little side note, Danielle Smith, the Premier of Alberta, was pushed really hard on this stuff in an interview that she did at the Canada Strong and Free conference, and she didn't budge at all. She didn't say, like Rustad, that the Canada Health Act is the problem, and she seems to be a little bit leery still of coming out and saying that she supports more private payment for care. But I think Rustad could be the first mover, and if so, then we quickly see other provinces fall into line. So that's all I'll say about that. Christine, tell us about where you were this weekend. We were all in different provinces doing different talks.
Yeah, I was in Ottawa. Don't be too jealous, guys.
Oh, wait, that's not a different province. That's technically Ontario.
It is, yeah.
Sorry, Ottawa.
Sometimes it feels like a different planet. So today I just got back from Ottawa. I was at something called the Digital Justice Summit, which is put on by Open Media, which is a sort of digital transparency organization that cares a lot about civil liberties. And it was co-hosted by Open Media and the National Council of Canadian Muslims. And both groups have some concerns about Bill C-63, which is the Online Harms Act. And the conference covered a lot of ground because Bill C-63 covers a lot of ground. There were panels about the proposed Digital Safety Commission, panels about child exploitation. And to be clear, I think basically no one disagrees with stricter penalties for child sexual exploitation. That is not the controversial part of Bill C-63. But the really controversial parts of C-63 are the new criminal penalties for hate speech, which include a standalone hate crime offense with the possibility of life imprisonment, as well as peace bonds against future speech. This has been what's referred to as the thought crime provisions of the criminal code. And then there are proposals to bring back what is called a civil remedy for hate speech in the Canada Human Rights Act. So I was on the panel about the civil remedy, the Canadian Human Rights Act amendments. So basically what this is, it's a return of Section 13 of the Canada Human Rights Act that was killed in 2014 by the Harper government. And it was killed because it was pretty badly abused. It was used to bring complaints against opinion writers, mainstream media, and even members of the clergy. So I was on a panel. We kind of had the spectrum. My panel had a spectrum of opinions. Not every panel was like this. So I am opposed to bringing back the civil remedy. I've done a lot of YouTube videos about this. We've written a lot of columns about the problems with the civil remedy in these amendments and how it would chill speech. The panel I was on also had Professor Richard Moon from the University of Windsor, and he actually had written the report back in, I think it was 2014, might have been the year before, but that called for the removal of the civil remedy, Section 13, and that resulted in the removal of the civil remedy. He also seemed to think it had been misused, and his big thing is that this hate speech fits really awkwardly in human rights legislation, and he thinks that the criminal code is better and more appropriate for these most extreme forms of speech. And then the other panelist was Sunil Gurmukh. I apologize, Sunil, if you're listening and I've mispronounced your name. And he is pro bringing back the civil remedy. So we talked about kind of the things that had happened that led to, in 2014, the civil remedy being removed. Professor Moon kind of made some allusions to the facts, but I thought it was important to talk about what actually happened. And the two big, I guess there were three big stories that resulted in like a lot of frothing by the media and anger among the public about the abuse of the civil remedy. And the three stories were Mark Steyn, who published in the mainstream magazine Maclean's some op-eds and an excerpt of his book, America Alone. There was also, and he was brought before the Canadian Human Rights Commission. Ultimately, the complaints were dismissed. The commission found that it did not rise to a level that should result in referral to the tribunal. Then there was also an investigation by the Canadian Human Rights Commission against a Basilian priest named Alphonse Devalque. And Devalque was, he's a priest, he's a member of the clergy, and he had published in a Catholic magazine basically about his pro-life position and opposing same-sex marriage, quoting the Bible, catechism, Pope John Paul's statements. And like Stein's complaint, his complaint was made by a member of the public who didn't like his comments. And his complaint also, there was an investigation and it was dismissed. And then the other thing that led to a lot of media coverage was Ezra Levant. But Ezra's situation actually did not involve the Canada Human Rights Act. It involved provincial legislation, the Alberta Human Rights Act. So it was actually different, but it kind of fit into the same narrative, even though it was different. And the investigation against Ezra was also dismissed. But the important thing to know is that when you have an investigation brought against you for something you tweeted or something you published, you almost certainly are going to have to retain counsel for that investigation. The Father DeValk, I think, spent $20,000 in the investigation stage. So the on the ground way I think that this is going to play out is you kind of, if this is brought back, you're going to have someone who doesn't like something that you said. They're financially incentivized because they bear no cost of complaining. But if they're successful, there can be up to $20,000 awarded for you to pay to the complainant. So there's a financial incentive with no financial burden. So somebody doesn't like you, they don't like what you said, they complain to the commission. Some bureaucrat reads your tweet and says, we're going to start an investigation. So you are faced with a choice. Do you take down your tweet, or do you hire a lawyer, pay the lawyer, proceed through the investigation that could end up at the tribunal? And the tribunal can order not just that $20,000 in costs against you to pay to the complainant, it can also order $50,000 for general to be paid to the commission or to the tribunal. So like a general revenue penalty. So you're potentially liable for up to $70,000 plus your costs of your lawyer. So what do you do? Do you do that? Or do you just take down the tweet, take down the post? I think a lot of people will just choose to take it down on their own. And then the commission can say, oh, we're not censoring you. You did this on your own. But really, it's the threat, it's the risk. That's part of the censorship. And I think that it's a pretty serious threat. And the government has said that this is different from the old version because, if the complainant is abusing the process, they can order penalties against the complainant for costs. But abusive process is like a really high burden to meet to show that that threshold is actually met. So I think it's not actually an appropriate guardrail. One of the things that was really interesting to me about this panel was I said that one of the concerns I have is that since 2005 or 2007, that was the period where Mark Steyn had published all of these things. And the commission ended up dismissing those complaints. But since that time, I think that the Overton window has really shifted. And I'm very skeptical that today's commission would dismiss the complaints. I think that they would likely refer that to the tribunal. And then the tribunal might today, if they had the power, might actually order those costs, those penalties against Mark Steyn if that were to happen today. And I said this, and Professor Sunil Gurmukh disagreed. He said, no. This definition of hate is settled. They found it in 2005. They would find the same thing today, even though, like the Supreme Court is not finding the same things today that they were finding in 2005. So I don't know why anyone would buy that argument. And Professor Moon disagreed with Sunil. He said, no, I do think that today that a tribunal would find that Mark Steyn's speech met that threshold. And look, this is not a defense or an attack on Mark Stein's speech. I don't personally agree with what Mark Steyn wrote in those columns, but I do think today it would be chilled. That speech would be censored. And I think when he wrote it in 2005, it actually wasn't even that far outside a mainstream view. And neither was the priests who opposed same-sex marriage. Back in 2005, that was like a mainstream position to have, even though today it's not. And I don't share those views either. Like, I'm pro same-sex marriage. But I think that that's the problem with hate speech, is that there's this subjectivity and there's that expression, yesterday's truth is today's joke, like something that we held out to be completely reasonable, mainstream, and true, in 2005, today we make fun of and think is absurd. So when you give the power to a tribunal to make these types of determinations. I think and you give this squishy standard of what is hate speech to the public who has no understanding of what it is. You're going to completely overwhelm this tribunal with complaints about all kinds of things that are just like maybe not even offensive. It's just something people disagree with. So I think it's a bad idea. And that's what my remarks were about. And some of them were well received, others were not, which I will describe in my bad legal take. Do you want me to do my bad legal take right now, Josh, and Joanna, or should we go to one of you?
Well, before I forget, I wanted to respond just very quickly because I've seen over the past week that there's rumblings that, assuming Parliament isn't prorogued, which is a strong possibility, that they will bring back, or they'll bring a new version of C63 that will remove the potential life penalties for, advocating genocide or for hate motivated other crimes, and they think this will solve the problem. But the biggest problem by far is giving the Canadian Human Rights Commission all this power again. So I don't think that would really satisfy any of the critics. And the Conservatives, meanwhile, Michelle Rempel-Garner is going to introduce her own private members bill that would aim at amendments to the criminal code to target stalking, extortion, and uttering threats online, which are already arguably illegal, but I guess would be clarified a bit. So yeah, that's all I wanted to say to add to your discussion. Joanna?
No, I mean, just, yeah, the fact that you have like several experts on free speech law that can't agree about what standard would have been applied to Mark Steyn is the problem in and of itself. Like, it's a toss-up.
Right?
Maybe it would have been, maybe it wouldn't have been, but the ambiguity is itself the issue. And I feel like people on the other side of this issue never understand that. So yeah, let's hear the BLT.
Yeah, I'll add to that there were a number of law enforcement who were at this event, and they were on panels as well, and they said that it's a difficult definition to work with, and there's a lot of misunderstanding among the public about what hate speech is. So, okay, here's I'll explain what happened with this bad legal take. So one of the things I said on my panel was, I was talking about the problems with the law, and then I was talking about some of the political problems with the implementation. The first problem was tying all of these controversial amendments, like the changes to the criminal code and the changes to the Canada Human Rights Act, which the government knows are controversial. They tied this to changes that are supposed to create stricter penalties for child sexual exploitation. And I said that that's like completely a cynical thing to do, because if they really cared about the child sexual exploitation issues, they wouldn't make those changes contingent on also passing these controversial changes. So that was one political criticism. The other political criticism I had was I said that the Trudeau government completely bungled this file by appointing that Dehaas guy as the head of the Canadian Human Rights Commission. And Dehaas had made a bunch of, public statements and about Israel, and had been involved in like anti-Israel divestment panels. He had used a pseudonym on social media to make various posts that some people found to be either anti-Israel or anti-Semitic. And what I said was,
it wasn't even a pseudonym, by the way. It was his full name that he went by at different times, right?
Right. Yeah. So he had like two different names. And then one of the issues was I think he had not been completely forthright about which names he was going by and when. There was some like
he wrote it misleadingly, as though one of the names was Jihad, and he wrote it as like a middle name, and it was the investigation found it was deliberately misleading.
Yeah, so I said that by appointing a person like this, where a lot of the reaction among groups in the Jewish community was very upset, and I said, look, whether you think what Dehaas has done is anti-Semitic or not anti-Semitic, what his appointment did with these facts, his appointment undermined that community's trust that they would be treated fairly by this commission when this individual is the head of it. And so, I think that that's a fair take, given that that's exactly what happened. I mean, there were groups among the Jewish community who were completely upset by Dehaas's appointment. Dehaas ultimately resigned, I think within days or maybe a week of the appointment. So that's what I said. And I got an email following my panel titled, I won't say who it's from, but it was titled Surprised and Dismayed. And then the person said, "Hello, Christine. I was aghast by what you said on your panel about Dehaas. There was no ambiguity in the report of the investigation as a result of the allegations that were made after his appointment was announced. How could you suggest otherwise?" So, it's sort of saying that the investigation found that Dehaas was not anti-Semitic. And look, I had said I was clearly not taking a position on whether or not his statements were anti-Semitic or weren't anti-Semitic. Like I did not take a position on how his statements should be interpreted. What I said was that in appointing him, when his record was what it was, it undermined the trust that's required by stakeholders in the Jewish community, who are actually subject most disproportionately of all groups to hate crimes. So that's a completely accurate comment given what we saw. But this idea that I'm so aghast that Christine observed facts is I think that's a bad legal take. I think it was a mistake to appoint Dehaas, and it undermined the government's credibility that they could be trusted to bring in these amendments. Anyway, that's my bad legal take goes to the author of that email. People always like it when we're under attack, and I am under attack, but I'm okay with that. Josh, what's your bad legal take this week?
I'm also aghast this week. So anyway, my bad legal take goes to University of Calgary Law and Health Policy Associate Professor Lorian Hardcastle, who was among, frankly, many professors in Alberta who decided yesterday to dunk on Danielle Smith for announcing that she would add the choice to reject medical treatments to the Alberta Bill of Rights, which is an obvious nod to those who were coerced into getting the COVID vaccine. And Hardcastle tweeted, quote, "We already have a right to make medical choices without coercion, so it isn't clear that what this is designed to accomplish other than continuing to dangerously pander to the anti-vaxxers." And honestly, while this, Alberta Bill of Rights might be ignored in a future pandemic and it only applies to legislation that the province itself brings in, I still think Hardcastle's tweet shows just how badly we need to push better for protection for bodily autonomy. Because this claim that people were able to make medical choices without coercion during the pandemic is just not supported by the evidence. And it feels honestly like gaslighting to say otherwise. Thousands of people lost their jobs because they wouldn't get the vaccine. And if you talk to regular people, many, many, many people will tell you that they only got it or primarily got it because they were coerced. And as we've mentioned before in this podcast, a woman named Annette Lewis was denied access to an organ transplant list because she didn't take the vaccine. And even after the pandemic had passed, even after she could show evidence of infection-acquired immunity, Alberta's doctors still decided that she should not get an organ because she wouldn't get the COVID vaccine. And of course, there were the women that we've worked with in British Columbia, including a teenage girl named Erica who suffered pericarditis after the first dose of the vaccine, who was told she needed to get a second dose, despite that very serious reaction the first time, if she wanted a vaccine passport that, recall, was needed to do just about anything, including, socializing. So that was really cool. And to say that no one was coerced, it's insane. It just doesn't line up with the evidence. And by the way, I think we might have mentioned this, but we still don't have a result in our appeal of that BC Vax passport case. It's been almost a year, which is unusual, and we don't know what's going on with that, but we hope to have a result soon. So my bad legal take goes to all those profs claiming that people weren't coerced into medical choices during the pandemic and who arrogantly scoff at efforts to prevent that kind of injustice from happening again. Joanna, what's your BLT?
Yeah, anytime. We're happy to hear from you, BC Court of Appeal. So my bad legal take of the week goes to the Manitoba Southern Chiefs Organization, which has asked a court in Manitoba to declare Lake Winnipeg a person with constitutional rights to life, liberty, and security of the person. Grand Chief Jerry Daniels said that the lake has its own rights. The lake is a living being. And a lawyer is quoted in this reporting from the Globe and Mail, who even he had argued that the Athabasca River should be treated as a person. But he observes what they're really asking for is substantive rights to be given to a lake. What does liberty mean to a lake? Those kinds of cases require a bit of a paradigm shift. I think the Southern Chiefs will face an uphill battle, noting that the Manitoba case goes further than any he's aware of in seeking legal rights for a specific environment. Look, this is being supported by environmental NGOs. Policy-motivated legal paradigm shifts are always a bad idea. Like, take the bigger view. There must be a more, if the underlying motivation, the reporting also talks about some reporting that Manitoba Hydro had not been doing proper environmental assessments of its activities on Lake Winnipeg. And there is surely a more parsimonious way to force environmental assessment, which is one of the most heavily regulated areas in Canada. And outside of natural persons, corporations, you'll recall, which are obviously not natural persons, are understood in law to be legal persons and have certain rights and obligations. So they can own property, they can sue and be sued. So you can hold a corporation liable for damages. They can enter into contracts. And I just don't think, I don't think anybody would have much luck collecting damages against Lake Winnipeg. Beyond some fundamental paradigm shift, it is true that in New Zealand, a river was granted the same legal rights as a human being in 2017, interestingly. But I'll close this off with some commentary from an Indigenous friend of ours that I ran this by. And this was her response. She said, yes, there are all kinds of laws, teachings in Indigenous culture around how to treat water. Water is Mother Earth. Women specifically are carriers of life through the water they grow life with in their bellies. But in my view, asking the colonial system, so the courts, to recognize and protect your customary Indigenous laws is bonkers. These people are knocking on Ottawa's door and asking them to wrap, or I guess in this case, a Manitoba court's door, and asking them to wrap the colonial laws around them for protection. Are we exercising sovereignty, or are we still running after the government to wrap us in Hudson's Bay's blankets? Good grief. So I could truly not say it better. Bad legal take to Southern Chiefs of Manitoba.
All right, well, that's the show. As usual, we ask you to rate us, review us, and subscribe if you haven't already. And you can support our work by subscribing to our YouTube channel, by following us on X, by visiting our website, theccf.ca. We're on Instagram now. Christine's on TikTok now. And you can also keep up with our work through our Freedom Update newsletter, which is written each week by our colleague Russ. The CCF is a nonpartisan legal charity funded by donations, so please donate on our website if you can. Thanks for listening.